we also have with us today the Honorable Judge Eric Menhert. I'm sorry, I have a cold today. Who is joining us. He's the Chief Judge of the Penobscot Nation Tribal Court, and he's going to talk about some exciting expansions to tribal court jurisdiction that are coming about as a result of both some federal changes with the Violence Against Women Act and also some state law changes that have enabled that federal legislation. And so I'm going to turn it over to Judge Menhert, but if Fatuma and Elizabeth, if you're willing to stay on as well, we may have questions for you at the end as well, that would be amazing. So thank you very much, and we'll welcome Judge Menhert now.
Thank you. I appreciate you having me here today and the opportunity to enjoy a conversation with everyone. I know that Donna Brown had previously presented, and she had given you some of the statistics concerning Native American women and what led to the initial VAWA. Those statistics are from the Department of Justice, and they tell us that 34%, that is more than 1 out of every 3 Native American women, will be raped in their lifetime. That 61%, more than 6 out of 10, will be physically assaulted in their lifetime. And on some reservations, Native American women are murdered at 10 times the national average. 86% of the rapes and sexual assaults in which the victims are Native are committed by non-Natives. 86% of which, in which the rapes and sexual assaults in which the victims are Native are committed by non-Natives. 68% of the aggravated assaults against Natives are committed by non-Natives. And yet, until recently, those individuals could not be tried in a tribal court. The law used to be that non-Natives who committed assaults against assault and battery against Native American women were subject to misdemeanor prosecution in the federal courts. That is a result of some jurisdictional laws that came about. The problem with that was that the U.S. attorneys declined to prosecute some 67% of the sexual abuse cases that happened in Indian country. In fact, in 2006, which is the latest data that we have, the U.S. attorneys prosecuted only 24 misdemeanor assault cases, sexual assault, domestic violence assault cases in Indian country throughout the United States. In 2007, the U.S. attorneys only prosecuted 27 across Indian country. Those were the statistics that led to the move to enact the reauthorization of VAWA, which expanded tribal court jurisdiction over a category of crimes called special domestic violence criminal jurisdiction. Real briefly, the history of tribal jurisdiction is in 1830, there was a case called Worcester versus Georgia. The Supreme Court of the United States said, no law runs on tribal land but tribal law. If you go in and it's a separate sovereign, if you commit an offense on tribal land, you're subject to the tribal laws. In the 1870s, there was a case called In re Crow Dog. In re Crow Dog was a case where an individual, one Native, killed another Native. The Native tribes said, this is what we decide as a penalty for that. And the U.S. attorney said, no, I would prefer to have something different. I want to hang him rather than allow the tribal penalty. Case went up to the Supreme Court. The Supreme Court said, no, the law is clear. No law runs on tribal land but tribal law. The tribe has spoken. That's what it is. Congress refused to accept that, and they enacted what's called the Major Crimes Act, which took 10 crimes away from the tribe's jurisdiction, and that's what led to the original erosion of tribal jurisdiction. 1978, there was a case that came along called Oliphant. Oliphant was a white man who committed an offense on tribal lands, on the Suquamish tribal lands, and was prosecuted by the Suquamish in the Suquamish tribal court system. The district court and the Ninth Circuit Court of Appeals both said, nope, that individual, he appealed for a writ of habeas corpus saying he shouldn't be prosecuted on tribal lands. Both of them said, no, you're subject to tribal court prosecution on tribal lands. Supreme Court in a 5-4 decision said, oh no, we're not going to allow non-natives to be prosecuted on tribal lands. And so that's the way it was from 1978 to 2013. In 2013, the Obama administration had moved through, in conjunction with the Tribal Law and Order Act, the federal reauthorization of the Violence Against Women Act. And at that point in time, the Violence Against Women Act, as passed by the federal government, included gave tribes special domestic violence criminal jurisdiction over non-natives, but in a very limited set of circumstances. And they set out some very specific rules. So if you're prosecuting a case in the tribal lands that included domestic violence, dating violence, or criminal violations of a qualifying protective order, and that the crime occurred within the tribe's Indian country, and the victim was an Indian, and that the defendant had sufficient ties to the community, then that individual could be tried in a tribal court. What occurred with that is that there were 6, in order to initiate that jurisdiction, there were 6 tribes that were picked as part of a pilot tribe. The Penobscot Nation was actually picked as one of the pilot tribes, but it was subject to the Maine Land Claim Settlement Act, which said if the state of Maine believes that it affects or preempts Maine law, then it has to weigh in and say whether or not the tribes could exercise that jurisdiction. And the state of Maine said they did not want the tribes to exercise VAWA jurisdiction at that time. And as a result, the Maine tribes were not able to exercise any of the VAWA jurisdiction. And it's important to know, when you're talking about VAWA jurisdiction, on tribal lands, the US Constitution does not apply. The Indian Civil Rights Act applies. And the Indian Civil Rights Act mirrors, and it actually contains some extensive, some additional enumerated rights that the US Constitution doesn't contain. It contains rights that were subsequently created by the Supreme Court, or penumbras of rights, I guess is what you'd say. So when we saw when that occurred, the tribes then moved in 2015 here in Maine to get the state to allow the tribes to exercise VAWA jurisdiction. And there was a number of things that went back and forth between the states and the tribes on exercising VAWA jurisdiction. And the first time the legislature did not pass the bill, it was held over. Subsequently, it was reinitiated, and in 2019, the bill was passed that the tribes could exercise VAWA jurisdiction. But there were limitations that the governor sought to put on it, and so it was held over from the session and eventually sent back to the legislature. What came out of the legislature was a Maine VAWA that was significantly different in some ways than from the federal VAWA. The Maine VAWA required that the tribes exercise a 12-person, if they exercise tribal court jurisdiction over a non-native, that they have a 12-person jury. Under the federal VAWA, it's only a 6-person jury. The Maine jurisdiction contained a provision that required mandatory reporting to the State Bureau of Identification. Under the federal VAWA, there is no mandatory reporting. And this is probably the biggest difference. The Maine VAWA Act specified the specific crimes over which the tribe had jurisdiction. It limited the tribe's jurisdiction under the Maine VAWA Act to Title 17.8, Section 207A, which is domestic violence assault, domestic violence criminal threatening, domestic violence terrorizing, domestic violence stalking, domestic violence reckless conduct, and violation of a PFA. Those were the scope of what tribes could exercise a jurisdiction over a non-native in tribal court. Under special domestic violence criminal jurisdiction, the DV crimes were not specified. The crimes, the general categories were specified, which were domestic violence, dating violence, and criminal violations of a protective order. But it was up to the tribes to define how those terms and what laws existed under those terms. And so the tribes could define what they wanted for what constitutes a domestic violence crime. And then the final difference was in the suppression hearings, the state requires that the prosecution must prove the voluntariness of an admission. And under the federal VAWA, the issue of a suppression hearing wasn't addressed, but presumably the defendant had to prove that the admission was involuntary. And so that was the state of the law. There are only 27 tribes in the United States that are actually exercising VAWA jurisdiction at this point in time. And that was the state of the law up until actually about 2 weeks ago, when the reauthorization of VAWA came out. The reauthorization of VAWA now specifically includes the Maine tribes, which is a provision under the Settlement Act that said that the Federal Settlement Act that said 1735B 1725 said that if the federal government specifically includes the tribes in Maine in the legislation, then it applies to the tribes in Maine, and it did. So the law we now have is going to, where the tribes will all be able to apply the federal VAWA law rather than the state VAWA law. The federal VAWA law is significantly more expansive now as far as jurisdiction goes. The federal VAWA law, which will is effective after October 1 of 2022, provides that child violence, crimes defining child violence, are now included under tribal court jurisdiction. Sexual violence are now included under tribal court jurisdiction. Stalking is now included under tribal court jurisdiction. Sex trafficking is now included under tribal court jurisdiction. Assaults of tribal justice personnel are now included under tribal court jurisdiction, and obstruction of justice charges are now included under tribal court jurisdiction. The crime, in order for the tribes to have jurisdiction, the crime still must occur in Indian country on tribal lands. The victim must be an Indian for most, but not all of the crimes, particularly the assaults of tribal justice personnel and the obstruction of justice crimes do not require that the victim of that crime be a tribal member. And the defendant having ties to the community is no longer a condition of the exercise of jurisdiction. It used to be that you had to prove that somehow the defendant had some tie to the community, either they lived or had a relationship with an individual on tribal lands or were employed by the tribe. That's no longer the case. If somebody comes onto tribal land and commits one of the covered enumerated offenses, the tribal court can exercise jurisdiction. The definitions of those charges are left up to the tribes, which and to my mind, it's going to create a conflict, and I see the potential for a conflict with the state jurisdictional requirements, because the state requires under the Implementing Act, the tribes are all required to exercise jurisdiction over crimes that are identified by the state. And so, and when you come to tribal court, the tribes are required by the Implementing Act to exercise Maine criminal law as the law which governs in tribal court. Now you're talking federal preemption, which is saying the tribes do not have to live by at least for these areas, the tribes do not have to live by those definitions. They can create their own definitions of crimes. And for instance, one of the anomalies is the tribal courts only had jurisdiction over misdemeanor offenses until the Tribal Law and Order Act of 2010. So what you would see tribes doing, and the Lakotas did this at Pine Ridge, they actually had a murder charge that was a misdemeanor offense so that they could prosecute, and in fact did. They had a case where the federal government refused to prosecute a murder offense on tribal lands, and they prosecuted it as a murder offense under their tribal code. And so you see tribes doing that as they define the terms and you wish to exercise a jurisdiction. I think that there may be some challenges with regards to that, as far as how do you meld the two together, as far as Maine criminal law that the implementing act requires, and how do we the tribes define the different categories under federal VAWA. Now, one of the interesting things that's really I think it's a benefit is that both the tribe and the state, they're dual sovereigns, and the dual sovereignty rulings from the Supreme Court have said that as dual sovereigns, their jurisdiction is concurrent, meaning that there is no double jeopardy. So even if you're tried in the tribal court or you're tried in the state court, if you're tried in the state court and acquitted, you can still be tried in the tribal court, and vice versa. As dual sovereigns. And the State VAWA Act specifically recognized that as a provision of concurrent jurisdiction in the State VAWA Act. To exercise the VAWA jurisdiction, there are a number of requirements that the tribes have to meet with regards to the DOJ. There are 13 questions that they asked of the pilot tribes, and basically those 13 questions they ask of all tribes before they exercise jurisdiction. I think the only real differences that you would see is that they require that the tribal judge be a law-trained judge. That's not something that you see everywhere. And the other really interesting one that I have never seen anywhere else in my career, 38 years, is that the tribal judge has to advise any individual that's brought to court under the VAWA jurisdiction that they have the right to petition for a writ of habeas to the federal court, and that not only do they have the right to petition for a writ of habeas to the federal court, but they have a right to seek a stay of any period of incarceration imposed by the tribal court during that petition for a writ of habeas. And the new provisions of VAWA 2022 require that not only do we tell them that as a tribal court judge, but that we get that in writing. So we're going to be doing a form that requires the individual to sign off and acknowledge that they have been advised of their rights to do so, as far as that exercise of jurisdiction.
Okay, so my name is Kara Cookson. I'm the Victim Witness Advocate Coordinator for the Attorney General's Office. I work with all the VWAs around the state. And I'm here today with Dot Barnes, who's the Clerk of Courts for the Passamaquoddy Tribal Court at Indian Township, and also Dennis Mahar, who is the Prosecutor for the Passamaquoddy Tribal Court at Indian Township. And they're here today to give everyone an overview of how their court works, the history of the court, and all the things that would be useful for you to know about working with their court and supporting victims who may be involved in a process going on in their court. So I will allow both of you to introduce yourselves, and you can talk a little bit about your role and how long you've been affiliated with the court, how long you've worked with the court. Maybe Dot, we can start with you.
Yeah. Okay. Well, my name is Dot Barnes. I am a member of the Passamaquoddy tribe here at Indian Township as well. I'm the court clerk. I have been involved working in this position here at Indian Township for the past almost 7 years. I also had a time where I worked at the Passamaquoddy Tribal Court at Pleasant Point for approximately 10 years as well. So welcome everybody.
And Dennis?
My name is Dennis Mahar. I've been practicing law in Washington County since 1986 and have been practicing in the Passamaquoddy Tribal Court since shortly after that. My role as prosecutor has been only for the past 2 years. Prior to that, I did pretty much all other aspects of practice before the tribal court judge. I also, currently still have a general practice in state courts as well. My role as prosecutor of the Passamaquoddy tribe is about, I don't know, maybe a quarter of my time between the two courts at Indian Township and Pleasant Point.
Great, thank you. So I'm wondering if you can give us a general background of the history of the Passamaquoddy courts in particular, how long they've been around, how things got started, to the extent that you know that history.
Okay. Dennis, you want to chime in on that?
Okay. I came into practicing in tribal court in 1986 or early 1987, as I said earlier. At that point, tribal court was still fairly new. It became recognized when the Maine Indian Land Claims Act, both federal and state, were passed in 1979, 1980. And those acts established the courts for the Passamaquoddy tribe and the Penobscot Nation. As I understand it, the first judge of the Passamaquoddy Tribal Court was actually a layperson, and that didn't prove to work out very well fairly quickly. And the first attorney judge of the Passamaquoddy tribe was John Romay, who later went on to be a state district court judge. And the judges of the Passamaquoddy Tribal Court have been attorneys pretty much ever since. The jurisdiction of the court has evolved a little bit over the course of time, but it basically has the same jurisdiction as the state probate courts and the state district court.
That's great. Yeah, and that's a great lead into my next question. Folks will have heard a little bit about sort of the overall history of the criminal jurisdiction, and especially the more recent changes with VAWA, and a little bit about tribal sovereignty and what it means. But I'm wondering if you could talk specifically about the Passamaquoddy courts and what the sources of criminal and evidentiary and procedural law are that get applied, including victim rights law, and so how people can think about what the sources of law are that end up in the court.
Well, for the most part, the Passamaquoddy tribal court has adopted the main rules of procedure. There are a few exceptions to that, and they've also adopted the Maine criminal code. So for the most part, they follow state law. There are some fairly significant exceptions to that, including the Passamaquoddy Child Welfare Code. So our procedures for child protective cases are different than the state's by quite a bit, because those laws are, the tribe has not adopted the state, Title 22A to be its law. But victim law, we try to follow the same rules that the state does with respect to victim input into crimes, and we try to include the victim in discussions of resolutions of criminal cases.
Great. So that makes it easy for folks to remember, is that 17A, the victim rights statute, is the statute that would apply in the Passamaquoddy Court as well. So can you talk more about just the staff of the court? So who comprises the staff, and who does what, and also who folks should call for different issues?
I can answer that. Well, as far as the staff is concerned, there is myself, of course. Prior to that, before it was just me. There was nobody else that worked in the court every day, 5 days a week. We recently have hired a victim witness advocate on a full-time basis, so she's fairly new. So we're working out how that whole structure is going to work, primarily between her and the prosecutor, as cases come through. So, she's readily available here in the office, but as far as staff goes, we're pretty limited. And then, of course, at any time I can pick up the phone. I can call Dennis, our tribal prosecutor. I can call the judge, and have any kind of conversations that I need to have if I need to reach out for something. But staff it's pretty small. So, and at Pleasant Point, it's the same way. They have, pretty much the same setup. I don't believe that they have an advocate, but they have everything else.
Yeah.
Yeah.
So to be clear for folks that might not be familiar, there are 2 Passamaquoddy Tribal Courts, one at
Yes.
Indian Township and one at Pleasant Point. So 2 different
Yes.
communities.
There's 2 different communities. It's the Passamaquoddy tribe as a whole. We have the 2 locations, Indian Township and at Pleasant Point, but we both fall under the same rules. Everything the same applies. It's all, and that is governed by our joint tribal council, which is the governing body of the Passamaquoddy tribe.
Great.
But that, we also should point out, I think, that even though the joint tribal council is the overall governing body, and that's also recognized in the settlement acts, there are 2 separate governments for Pleasant Point and Indian Township, and for day-to-day operations, they're very separate.
Yes, that is true. That is true. Yes, we have both reservations each have a chief, a vice chief, and 6 council members, which comprises the joint tribal council when necessary, when issues arise that need to be addressed.
Great. Yeah, that's really helpful clarification for folks who might not be familiar with the tribes. Okay, so my next question is, and this actually gets to the staffing, right? How many cases do you tend to hear each year? And especially after the VAWA jurisdictional changes, has there been a change? Have you seen more cases, and what does that look like?
Dennis?
Well, you're probably better with the counts than I do, because I don't keep track of the counts of cases. Although actually Wabanakis Women Coalition seminar several years ago, I happened to be sitting beside the Passamaquoddy Tribal Court judge, and we fairly early figured out that we clear more criminal cases than the U.S. Attorney's Office does. with a staff of one judge, one prosecutor, and 2 or 3 public defenders.
That's impressive.
Well, I'm not. It doesn't feel like that many cases, though. But of course, in federal court, they're going to be more complex issues. But
yeah,
I don't think I have yet seen a VAWA case at Indian Township. I have had one in Pleasant Point.
No, there has not been any VAWA cases here as of yet. Prior to COVID, because COVID, as we all know, put a damper on a lot of things and slowed down things. But prior to COVID, we, as far as counts are concerned, and of course we have, we're not just focusing on one type of criminal cases, like all criminal cases, criminal defendants. It could vary where we have anywhere upwards of 100 to 50. I mean, it just varies. But prior to COVID, that's what it was. But now, since things have kind of really slowed down, and I'm not sure why, but the numbers aren't as high as they were prior to COVID. That is for sure.
Sure.
Mhm.
Yeah. No, that makes sense.
Yeah.
So what does the court schedule tend to look like? How often does the court hear cases? How is it all overall structured?
Well, prior to COVID, I'm not prior to COVID. I'm stuck on COVID. We hold court generally once a month, where we have live court, and whatever cases that are due to be heard, whether someone was arrested or arraigned, for criminal cases, we generally do those right first thing. We do, if there are any protection from abuse or harassment cases, any probate matters, any civil matters, family matters, child welfare. Our day could look really, really crazy sometimes, but lots of times things, if there's agreements or, things like that, but we have it once a month. And then of course, if we need to have any special hearings or anything like that, we have to, set them out for a special day, just because we wouldn't have the time in a regularly scheduled court date, which does happen, and we're able to do that pretty much. But yeah, that's the way historically it's always been, since I think they started tribal court back after the Land Claim Settlement Act and everything started happening. But yeah, you could be here for a variety of things, and we put everything on the list and try to get through the list as best we can. And if we have to push something over, we push something over. So it would be nice to be able to have special days for special things, but we just don't have the ability to do that. So
Sure. Dennis, do you have any reflections on the schedule and sort of how things work?
Well, when I first started, we would do Pleasant Point and Indian Township on the same day, which was kind of an interesting way of doing things, because we would start off at Pleasant Point in the morning and run through what needed to happen down there, and then come to Indian Township in the afternoon. That proved to be too short a time fairly quickly, and then we moved to separate days for each of the courts.
Was there a good lunch spot in between?
Well, yeah, usually that was through the McDonald's drive-through or something in Calais, but that's if we need special days, and usually those are going to either be for family matters or child protective matters, because they have a tendency to take longer than your average misdemeanor trial. So those do happen. What have we had this year so far for special days? 3?
probably, yeah, probably about 3.
Mm-hmm. And probably 2 or 3 for Pleasant Point. So,
So I think another thing that I'm certainly curious about, and I think other folks would be curious about, is if there are ways that the court ends up being particularly unique compared to the state court, either in terms of, we talked a little bit about procedure, and it sounds like the state court rules are adopted, but maybe in terms of outcome, maybe in terms of programs or sentencing, or are there distinctions that especially people who are working in our state courts should be aware of?
We probably try to do more more restorative justice kinds of things, and make punishments be more individualized than kind of a cookie cutter formula, the way that state courts, in part because of higher volume and in part because these are fairly small communities, and everybody knows what everybody's needs and issues and troubles and so forth are. So we can be more restorative than and more individualized than the state courts can.
That's great. Any
Yeah,
reflections on your part? Yeah.
absolutely. Our communities are very small, and everybody, like, I live in the community, and everybody knows everybody. So I think if I were to go into the district court, I wouldn't have the clerk knowing my everyday, what my family's about, or, what my life is about. I don't see that, because we don't interact with people as much, but here we do. And that's just the way I say that. I think that we're unique is that we look out for each other, or we try to look out for each other as much as we can. And I probably have a more intimate relationship, I guess, if you want to call it that, with people that come through the system. And they feel maybe a little more comfortable with me because they know me. This is my home. We all live together in the same place. So that is it can be a really good thing, but sometimes it cannot be so good. So
Yeah, I would think especially in interfamilial cases, right? Like it can be really complicated.
it can be, but as for the most part, it's okay. It's okay. And people, you deal with them like you would deal with anybody else, but you sometimes a little bit more.
Yeah.
That's the nature that's the nature of the rural areas of the state in general, but it is more amplified here because what's the community population at township? 600, something like that, or
Yeah, between 600-700 probably. Yeah.
And Pleasant Point, I think, is a little bigger.
Yeah, it's a little bigger. Yep.
But it is, generally speaking, if somebody's coming into the system, if I don't already know them, DOT does. And
Right. And I think that, that has to help the court make an impact, right? Because if you know people and this is a place where accountability happens, right? There's that added accountability because you see people in the grocery store, right? Yeah. So I think another thing that I'm curious about is obviously the tribal court criminal jurisdiction is more limited than state court jurisdiction, and most of our felony crimes are going to be heard in state court. And so I'm curious about what it looks like when defendants' conduct might be crossing back and forth jurisdictional lines, either because of the geography of where the thing is happening or because of the conduct itself. If there are examples of cases and sort of what it looks like working with the state courts to address the defendant's conduct or to work with victims as a whole, if you can think of examples.
There are a fair number of crossover cases, and probably most often those are when there's felony level conduct that's involved in it. And we have a working relationship with the local prosecutor's office, the local DA's office, to work through some of those issues. One of the barriers that we're currently working on is making sure that we have access to state court conviction records and vice versa. That's supposed to have been happening right along, but it hasn't for a number of reasons, not the least of which limited staff time, and also the system that the state uses is not compatible with anything that we have. So it's that the technology is still a barrier at this point, but hopefully there's light at the end of that tunnel as well. But right now, I think I have 3 cases that I can think of that have state court and tribal court components. And those are interestingly are at this moment all from Pleasant Point and not Township.
Sure.
I think that question it's kind of simple. When you think about jurisdiction, of course we have Class D and E jurisdiction, so we don't hear any felony cases. Anything that is a felony that's committed here on the reservation is, that's a no-brainer. It goes to state court. And then with the misdemeanors, correct me if I'm wrong, Dennis, but it depends upon victims, and we've had the non-tribal victim because we have non-tribal members that live here on reservation. And when, I don't know, I think VAWA may have changed that, but we haven't really been implementing, VAWA hasn't truly been implemented here. That, if it was a non-tribal victim, then the defendant would be summoned to state court. That's how it goes, right, Dennis? Or
That's usually how it goes. I have done well, and as I'm thinking of that, I've done one case where I've used VAWA in Pleasant Point, but it was actually not a criminal matter. It was a protection order matter.
okay.
That's another dimension too, right? Is to be able
Also
to
prosecuted a state, a non-tribal member for a violation of a protection order on the reservation against a tribal member.
That makes sense. So is there anything else that you think is important for victim survivor advocates in Maine to know about the Passamaquoddy tribal courts and how they function? Just anything else that you think would be important?
That they function primarily as a district court, but we may be more accessible than the state court system is.
You sure?
Yeah.
So if people, victims or otherwise, need to get a hold of us, they can usually find us.
Yeah.
Yes, that is so true. Yeah, like Dennis said, we pretty much, that's the way I've always viewed it, is we pretty much function like the district court does. And if somebody has a question about, anything really, all you gotta do is call, and, I will do my best to direct them in the right direction. It's, and I have my new advocate here, and, we can figure it out. There's no question, we can figure it out. And it just, it's being accessible, and that's what pretty much, that's what it is. I know the state courts now, if you call, COVID and they've shut down, and we've been pretty much open here. There was some few periods of time where we were closed to the public, but for the most part, we've been open to the public. Tried to be as accessible as possible.
And you don't have that same backlog, I would think.
No, not now.
Yeah.
Not now. We tried, we did for a little bit, but we've been open and doing live court. And even before that, we were trying to do, hear as many cases as we could, whether it be live or by Zoom or whatever. But no, we're pretty good.
Yeah.
We're pretty good now.
That's going to be a huge benefit to victims and defendants, right? I think one of the most frustrating things about being a crime victim is that the court process can take so long to resolve.
Yes. Yeah, we don't have that backlog like that. No.
No, if you are arraigned today, you can bank on the fact that your trial would be next month unless there's a good reason not to.
Wow.
Yes.
That's huge.
And actually, I'm old enough to remember when that was what it was like in the state court too, even for felony level cases.
Wow. Yeah. No, I think that's amazing. And I that's actually, I think, a really great place to leave off today. It's just and to thank you both for your tremendous service to the tribes, and everything that you're doing to uphold the sovereignty of the Passamaquoddy Tribal Court. I think is really amazing to preserve the sovereignty for the people. So thank you for that, and thank you for sharing everything that you know today. I think this will be wonderful for our victim advocates, our survivor advocates. So thanks.
Yes, you're welcome.
Thank you for doing the work that you're doing to try to make sure that everybody knows how to deal with the issues that are facing those victims and survivors.
Mhm.
Thanks.